Sarah, hey baby. Hey baby. You're the only one here so far. Because everybody's probably over there watching it. They'll come. Am I alive though? I don't even have a counter up. Oh, there it is. I was like, what the heck? Usually there's a thing in the left corner. It wasn't there, but it's there. You guys, we're late. I'm gonna put on Sarah right now. Sarah Boone, I should say. They didn't do a live of her court appearance for some reason, which didn't surprise me. But now Court TV is doing it as a premiere, so it's from the hearing from earlier. So let's watch it. If anybody's in here, I am going to play. All right, here we go. Here we go. Here we go. And I know I'll be behind, but I started it late, so if you guys were watching it over there, we're gonna have to. I want to watch it. We'll have to watch it again because I want to start it from the beginning. I kept checking all day too, but they didn't. They didn't do it live. So, but yeah, this is from earlier today. And how many were watching it over there? Moira, Lurka, Michelle, Kim. All right, let me play and we'll watch. See what's going on. We're about like an hour or so behind, but let's see what we got, guys. See how if there's anything interesting. I think they're just going over all the motions, like stuff she's asked for and stuff. So, all right, let's see. On mute. She looks all ready for business. Sarah, you ready? You ready, girl? She looks ready to go. Yeah, right. She's nervous. People in jail. I wonder if she has any jail friends. Oh, she got her piece of paper. She's ready to go. Got her pink handcuffs on. You go. I'm sorry. She makes me laugh for some reason. It's crazy that they're not even gonna let her take her handcuffs off. And she's representing herself. During trial, she will, I'm sure. Hi, Susan. Hi, Becky. She's got pink sandals on too, huh? They look like a light pink. Yeah, she has aged a lot, huh? You know who else is aged is what's her name? The mother of the school shooter that went to jail. Dude. Like a year in jail made her like age like 10 years. What's her name? Crumbly. Oh my lord, I feel bad for her. She looked so bad at her trial. Nope, not today. Nope, not today. Nope, not today. Lips sealed. No, it's fine. Is it already over? I'm sorry. I wish I would have saw it earlier. I was looking like all day, and then I was doing some stuff outside and down the basement, and then I just happened to look again, and I'm like, oh my god, they're like 45 minutes in. I got to do a thumbnail and do a live. Hi, Direwolf. Hi, Sizzle74. Jennifer Crumbly. Yep. She aged a lot, dude. I actually feel bad for her. I think it was pretty harsh what she got, to be honest. I wasn't very happy with that.
Case number 2020 CF2603, the state of Florida versus Sarah Boone State.
Catch Trump at the state. We inject the state.
Ms. Boone, raise your right hand to be sworn, please. Please swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you
Ma'am, good morning. Could you please state your full name and date of birth for the record for me?
Sarah Boone, 1077.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get your appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18th, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As to the depositions, the date are to be determined and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for. And again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those. So you're telling me at a later date, once I have that information, to revise them.
I'm giving you the opportunity to refile them. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs to With regard to defendant's motion for reservation of proposed cost to acquire expert witnesses for the defendant's defense and trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor, again, the issue here is with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of a criminal case for trial dated July 18, 2024 and received July 29th, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the courts had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State, 152 Southern 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepherd versus State, 17 Southern 3rd, 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied. Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I did not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period.
Thank you.
With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is regards to competency as opposed to having an understanding before you take someone's right away.
Ferretta pertains to a criminal defendants seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explained most of all of this, and as opposed to prior, so I would know what would happen or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence, or the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my rights counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you present.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that it's my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion. All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pretrial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense.
Yeah.
And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
That's her.
so I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay, and that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list in the USB.
Yeah, if we're gonna make this work for an October 7th trial date, Judge, I think September 1st is probably about the right time frame to have this in-court hearing, to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. Then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality, it is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
Understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion. has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions. And then later we can turn to her request and put on the record how we would go about going out to the jail to meet her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That is correct.
I'm unclear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I didn't know if my investigator and I are able to collaborate prior and review and then come to court with everything finalized and ready to go with the answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, etc., would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it, but it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever we deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review, because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here, just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it cannot be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive or research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So, if you could please look into that, because I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, if the USB drive or the, after our viewing here in court, state, is it your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay, all right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion, if there is a discussion we had about plea offers. One of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously have worked on the laptop with USB drives that he has furnished himself, bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
D. Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get them involved with fear of harassment or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically
Yes.
as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and it was provided by U.S. Mail. It was sent out last week.
I have yet to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with, the implementation of your USB drive.
Okay.
option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process,
It was served by U.S. Mail.
by U.S. Mail?
Mhm.
Yes. I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records, under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail. So by me trying to get a hold of the captain nonetheless, it's going to be a feat in itself. So I want you to know, if anything, that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing. So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
You can caveat in that order be unless it hasn't already been done. In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I would be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get that.
And what is your affiliation with the state?
I'm a homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you could file that notice, just identifying when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to, well, I'm in the process of working on it for the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptop is in quotes, closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please. So you're aware of what I have already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by bringing that topic up, I have that to also be looked over.
Okay.
Please. 9/17, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that will give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
have a deadline?
Well, we're setting them today,
I understand. So the 3rd is a what day? Thursday?
Tuesday. So the 17th would be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days, and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery today.
Wow. So in over 4 years, it comes down to me representing myself in 62 days.
I'm not going to answer that question.
Am I supposed to?
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. Those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay. And if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yea or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you've delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet, your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable, I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else if they just delegated the date and gave me a printed copy with your order and whatever information you have, I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay. Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testify in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to, and that are limited to only 15 minutes that I have to share with 62 other inmates. That is a hurdle, please, that I need you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Whom is it that I need to speak to in order for this?
We may be able to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and if also, because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is it that you're asked? Which, the protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding
Sure.
USB.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. What I did. Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So understanding that as of right now, you do not have hard copies, you'll be provided digital copies, and to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I will be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain, so I can see if I can have access to a regular phone, if I can have access to an internet. Right now, I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone, I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to the discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, they state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her, would be our suggestion.
Okay. Ma'am, are you amenable to that? That would 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists.
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these dates which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to many more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm stating my good causes now, if not, there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Mr.
Okay, all right. I will set a deadline for the review of September 26th.
Is the review that you're seeking out, please, for my exhibits and witness list?
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes, and if I may ask, please, what you're typing, is that for an order or for today's proceeding?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm gonna have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have made known to the court, I do not.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here. All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in. You can stay to the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk's going to go ahead and swear you in. All right, sir, good morning. Could you state your name for the record?
Sergeant Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown court holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir? Sir, good morning. Could you raise your right hand? Madam Clerk's going to swear you in.
You swear or affirm the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane.
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you with digitizing 2 bankers' boxes of information. And you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those, this drive here is a copy of all digital discovery that I have in my possession from Ms. Boone for the court's needs if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Okay, all right, the record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you please take custody of those 2 thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop and be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you could proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocol is provided to be by the captain of the jail.
Mr. Casey, could you please make note to Captain Giovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved.
I'll inform her.
Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 banker's boxes. Did you bring those back with you, sir? Okay, could you bring those back up? I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes? Okay, I'm gonna have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor, thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or beginning of next week.
I don't know. I don't know what happened. Hold on. Oh, there we go.
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it.
Okay, that's fine.
Okay.
It's blacked out.
Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable, yeah, if Mr. Lane, and Your Honor, in light of this, maybe it might be more appropriate for the court to go up to 10,000 for the investigator, because it sounds like he's already done a lot of work. So it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
One thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses since I'm out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC, if that's acceptable.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, saying that $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need an order for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will prepare the order and submit it.
All right, very good. Just send it to Ms. Barrios, so I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lake, thank you so much, sir.
Yes, sir.
All right.
Judge Payne,
Yes, ma'am.
forgive me. What is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants. All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing of, I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor. Thank you.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness from
He will be
my
there.
side also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought with you this morning.
Yes, please.
All right, if you could hand those to the deputy. Also, to the extent that the deputy has not already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you. It was read to you at the last hearing. but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document, proposing the dates for today's hearing. And, I guess it was some type of notice. That's what, please, that she was going to print out to give to me, so I have that.
Okay. Mary.
I did not receive that, nor did I receive this protocol list.
As to everything that was being discussed. Can you print out a copy of it? It should be in the court file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
Ma'am, with regard to one of your motions, the motion for defendant's immediate address correction, as identified earlier, there was a clerical error using the general PO box as opposed to legal mail. That's been remedied. So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail. Mr. J, if you want to approach, sir, to review the hand-delivered motions, it is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. The second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, -A, B, parentheses, submitted to the court by former attorney, parentheses S and parentheses, on June 28, 2024 for preparation of trial in her criminal case. Just review those, counselor, and just let me know when you're ready to address them.
Your Honor, in regards to the first motion, we need to notice the sheriff's office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed, I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay, all right, I appreciate that, sir. Ma'am, with regard to your request for discovery, or the hard copy discovery, you've advised me multiple times seeking to use a laptop. I've written correspondence from you asking for a laptop. That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding in communications with the captain, to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I've never.
You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom and movement, well, I'll notice the sheriff and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by Sergeant.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach. By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag or property bag that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those 2 bankers boxes. Ms. Barrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's 2 bankers boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs. I was never asked anything, just like my letters to you prior to you forfeiting my right to counsel. I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week. So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So if the document, what would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
I mean, I would entertain an or tennis motion to have it released from evidence. The concern, as in Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those 2 bankers boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those 2 bankers boxes because of A, storage, and B, because of the hazard. Now, if the jail's in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
I understand. I'm just trying to find a solution. So
Same.
if she moves Oritenis to release those 2 exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when the captain's back.
I think, I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
Okay. So if she wants to Oritenis, which means oral motion, move to release those 2 exhibits, the state has no objection. And it sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So I don't want to ask her, but perhaps the court can ask her that question.
Ma'am, the state has recommended a position for in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask of that of the court orally this morning?
I'm not understanding understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the captain and whomever, you can release them to me?
Granted.
No objection to her motion.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those banker's boxes. I will have Ms. Barrios coordinate a hearing for the 13th at 8:45. Why not? We cannot do it the 13th because it's pre-trial. You're correct. We will have a hearing on August 14th, if necessary, on Wednesday, August 14th at 1:30, if we need to address the jail's position in taking hard copies if Mr. Lane's unable to have it delivered. And Mr. Lane, you had advised earlier when Ms. Boone had inquired of you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that that information was provided to the jail on what date and to whom. Okay. All right. Thank you.
Your Honor,
Yes, ma'am.
what would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop, we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it if we need it. If we don't need it, we will not have a hearing.
Thank you. And then so there would not be needing to be made an updated evidence control sheet right now. It has been passed to Mr. Lane.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, I looked at 8:30.
Oh, that is the 9th now.
We're available, Your Honor.
Okay, Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Ms. Boone?
Please bear with me, just please, one moment.
Uh-huh.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd. That's deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided. The names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, you're representing yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom and during the evidentiary, the physical evidence that I might be able to utilize that?
So my understanding is there was an imaging done on your phone with software called Cellbrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person to hire. I know that defense attorneys in this area hire somebody named Richard Connor, C-O-N-N-O-R, and then that will be between you and the JAC about, and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him, with us being present if we wanted to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, a legal expert that can give me a near download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. There is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence, because like you said, there's so much of it would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We were going to make sure that that is taken care of.
And
That,
what was
just
that
as
date?
clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you, and to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior. So this would be a milestone, an epic milestone for me to be able to finally do that. So now, if I don't have what I need or I'm looking for, how do I go about? I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy near download of my phone. If it could be brought to you for physical, with the other physical.
So again, that is going to be something that requires an expert. And then if you get a defense expert and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, you're going to make sure that that is provided.
Okay, so that is not able to be included in the other physical evidence that you all are supplying?
No, what I'm saying is there's 2 different ways that I see phone extractions. One is the PDF, which is what I think you're referring to as the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program, and all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before, just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence of me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because
Okay,
it needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of its phone.
thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
Okay, so everyone is aware that I'm in the process of trying to talk to the captain. And handcuffs, okay. Your Honor,
Yes, ma'am.
I believe I am okay for right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access where I don't know if emailing or messaging or whatever, however it is that you and I can communicate. Rather than snail mail, I mean writing a letter. I don't know when I write a letter, how soon you receive it, because sometimes it's days or weeks that it is uploaded to the clerk's website. Do you have a general time frame of when you actually know of something? Because you already had my address correction, but I don't believe updated.
It's been updated now.
No, I mean on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or am able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Yes, thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or portal or whatever it is that I might be attached to in order to receive notices to be properly prepared?
Notices have been sent, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State, anything else?
No, Your Honor.
All right, we'll see you all Friday. Thank you very much.
Thank you very much.
We'll return Ms. Boone to the custody of the Orange County Jail.
I'm grateful. Thank you.
Yes, ma'am. Thank you.
I almost I know this isn't the popular opinion, and I don't feel bad for her in a sense, in one sense, but in some sense I do, because today I don't feel like she was trying to be hard or annoying purposely. She just has an annoying personality in general. So I do feel like she was just really trying today. I don't feel like she was trying to be difficult. She was just trying to figure it out and figure out what she needs to do and get try her hardest to be this is not what I want. Is there any way I need more time? I need this, but I don't feel like she was purposely trying to be hard type I feel like she just has that type of personality, and sometimes she is. I mean, I'm not saying she doesn't, but she has that personality anyway. So it's like, even when she's not, she comes across as unlikable. But like, I feel like she really was just trying. I really do. Like, she was just trying to get what she needed to get done. Like, she really doesn't want to, represent herself. She knows she has to. She's trying to figure out what needs done. She's trying to get like anything that she possibly can to help her out. Like, and I'm not saying like that, I know she brought it on herself, she should have took it serious when he kept warning her, but now she's in a position where she's like, hands up, like, help me, I don't know what to do, I don't want to do this, like, okay, I have to do this. So she's trying to do it, but like I said, I mean, she made her own choices, but I do think she was really trying today. I don't think she was purposely trying to come across as like a difficult. So yeah, I mean, there's a part of me that feels a little bad for her. I mean, because people could deserve things or bring it on themselves, but you could still feel bad for them because we're human, and I do still, in a way. Not that I feel like, I know she brought it on, but I could still feel bad. You know what I'm saying? The both could be true, where yeah, she brought it on, but yeah, I still feel bad because she is screwed and she knows it. And like, I don't know if it's too late for her to get a deal, but here's the thing. Now that she's representing herself, she would have to work that all out. Like, she probably, you know what I'm saying? She probably doesn't know how to even work a deal, right? So, I mean, either way, she's got to figure everything out. So, like, I wonder if they would offer her a deal now. The judge completely hates her. I mean, he's trying to be like a professional, and, of course, because he doesn't want her to be able to appeal either, but he has to do his job. And you can tell, though, he is going to take such a pleasure in sentencing her. I guess innocent until we go through the trial, but I do think she will probably get convicted. I do think the jury will find her guilty, just saying. But I do think he's gonna like it, because he doesn't care for her, obviously, but he's being professional about it. But he is I mean, he's making it hard for her. I mean, she made it hard for herself, I know, but I mean, he's like, nope, not backing down. So I don't know. I feel like if there's a way that she could get a deal now, like, I feel like she would be willing to take it, because I think she knows she's screwed. And I don't think she wants to go through with this trial, but she's probably going to try to figure out, what she could do, because, they're not giving her more time. And I get what she was saying. Like, yeah, he's saying 62 days. That's plenty of time for, to prepare, but not for somebody that has no experiences and being, representing herself or themselves or whatever, being a lawyer, not somebody that has no experience, because you have to learn the rules of just the freaking court on top of trying to plan a case, plan her defense. So yeah, I don't think no amount of time is really gonna do her justice anyway. I mean, she's screwed either way you look at it. I just wouldn't be surprised if there ends up being some kind of deal worked out. I really won't, because I feel like I said, if she could figure out how to get a deal, I mean, I think she would do it in a second. Don't you guys think? I don't think she wants to go to trial. I think she would take a deal. But I mean, who does she talk to about that, Yeah, I don't know if they would even allow her. And I don't even know, like, there's been a lot of people saying that she was offered one, but I still have not been able to find anything that says that she was. So, like, somebody said, like, at the beginning that she denied a deal, but I haven't. Does anybody know? I know I think I ask this every time I talk about her now, since somebody mentioned it, but I'm just hoping there'll be that one person that has some kind of like documents or something that says, yeah, look, there it is. Anybody? Is that true, or is it just like a rumor? Because that would be like, if she was already offered a deal and denied it, then chances are, her getting one now would probably be lower. But like, if she never was offered one, I heard that. Yeah, I know, Jonathan. People said that, a few weeks ago, or no, this might have been a few months ago. And it was news to me, but they just said they think. Nobody had any proof. So yeah, maybe it might just be like somebody talking and out spreading because somebody mentioned it, and who knows, but yeah. I mean, that's her best bet. Save the time, the energy, the money of the courts, the manpower. I mean, just do the deal. That would be good for everyone, really. Now I think the judge just wants to go through and watch her suffer, like through not suffer, but what's the word for it? Like whatever, watch her. Oh, I can't think of the word. What would be a good word for what we're going to be watching with her trying to represent herself? But I think he just is going to get entertainment out of it. Tricky, Moira. It's very tricky. They got her dead to rights. Hey, Stephen H. Laura Lou. I don't think it'll go 3 weeks. So they're blocking off 3 weeks, but he's, I don't think it'll go that long in the trial. I mean, maybe it might because of her being new, and like it might take longer because it might, because they're gonna have to walk her through things and it'll take longer her representing herself. I forgot about that. So it possibly could, but I don't see like, okay, she's gonna get some experts. Well, I mean, what kind of expert is she gonna get? Like, I mean, she already said that she zipped it, right? Or that she zipped it. She said, did she not say, she said she zipped it and left a part open, right? Isn't that what she said? Now I got to remember the interview, like that she left some of it open where he should have been able to open it. I mean, I know she's a lie. He couldn't open it, but isn't that what she tried to say? Like that she did zip it, but she left it. So like he should have been able to open it. So I bet you is her expert going to show that he could have unzipped it from the inside? I mean, was somebody going to go in there and try to, I don't know. Who knows what kind of expert she's going to get or who she's even going to try. I don't think she's going to have much of a case. Yeah, the video show. Yep, I agree, Moira. I mean, it's not going to fly, but yeah, she left it open enough. Yeah, that's what I thought. Hey, Angie, Brittany, finger open. Yep. I'm tired. But I'm glad I did this. I'm glad I saw this on at least in enough time where it wasn't to wait completely late. But I kept looking all day. I'm like, where is this? And if I was remembering, like a lot of her hearings weren't live streamed. It was just like it would come on after, when one of the local channels would upload it after. So then in some of the groups and some of the people that were live streaming it earlier or thinking it was going to be on, like there was people coming in saying, oh, it was canceled, the hurricane, it got canceled or whatever. So then I'm thinking, oh, maybe it got canceled, but no, it didn't. It did not. And so what do you guys think? Let me read chat. Hey, Rebecca, does anybody think that what was I gonna, hold on, I just lost my train of thought. Oh my lordy, what was I gonna ask? Does anybody think that does anybody think she will get a deal? Still? Her goose is cooked. Yeah. So she basically got denied all of her motions, right? Besides the address thing. And then what was the thing I caught the end where for her not to be, restrained, right? There's no way they could if she's representing herself. He said she wouldn't be, right? I heard him mention it, but by the time I tuned in, he was ending that part, so I missed what he said before that. I cannot, like, if I'm like completely in chat, like when I'm reading chat, I can't listen to what's going on and read chat at the same time. Like I have to alternate. So like if I'm like reading chat and type and reading, then I miss all the what's going on the video. It's like my brain can't absorb two things at the same time when in learn, you know what I'm saying, when you're trying to learn it. So yeah, I need to start watching stuff. Well, this one I couldn't because it was live, but well, it was the premiere. So, but I need to start, yeah, maybe watching things ahead of time if I want to be in chat. If the state don't even want her to have some co-counsel, they want getting any. Oh, well, no, Jonathan. See, I think they would rather like just be done with it though, because if she got a co-counsel, they would still have to go through, and then they would risk her complaining about like whining about it and everything. And they already, warned her. But I feel like a deal might be better. Like I could see the state possibly, because then they wouldn't have to go through the trial. They'd save money on all that. So I do think there's still a possibility. You don't think? Because I mean, even a deal with, let's say they give her like more mid sentence of, well, no, she can get up to life. It was 20 to life. And with a felony, oh no, it was 10 to, okay, wait. In Florida, 10 was the minimum sentence, right? But then it said 16.57 or something in Florida was the minimum. But then if you have a felony or any other circumstances, it could be higher, right? So yeah, she probably won't get any less than 15, but like, I mean, she could potentially get life. So I mean, even if she took a deal for 20, what would you do? Let's say you're in Sarah's position, okay? You could potentially get life. Probably not going to get life. I don't know though, with this judge, maybe, but potentially you could get life. And they offer you a deal of 20 years. Would you guys take it? Because she could possibly maybe 10, but then it also says something about like 16 for minimum. So I'm a little bit confused when it comes to the laws, because you can look it up and find two different answers. So let's say if the minimum is like, like around 15, would you take 20? Because then you could I think I would do it. I would take 20. I take 20 for a deal. Because I mean, she could get 30 life. She's not going to get 0. I mean, she's going to get convicted. I'm sorry. She's going to get found guilty. It would, if I don't think it's possible that she wouldn't. So if the minimum really and then she has a felony, she has a strangulation. So she has a violent felony charge basically. So I think that's going to bump up where the minimum's, I mean, 20. I would say like that bumps her up to 20 for like the minimum, right? I would take 20 if I was her. I don't think they'd offer her 20, to be honest. Not anymore. If she would have done it ahead of time, maybe. Yeah, I would definitely take 20. But I don't know. As stubborn as she is, she might not. Let's look at that law real quick again. I want to see something. I want to see where I found, because I found the 10 and then 20 if it was if you had a felony, right? But then, like I said, there was one where I saw 16. Do you guys remember that live when we were going over it? Then we found 16. All right, second degree. Hold on, let me look this up again. I want to see where that 16 came from. Okay, so second degree minimum sentence. Yeah, minimum sentence 16 3/4 years without the chance of parole. Second degree. So this minimum said, here, let me share this real quick. Oh wait, do I have the whole screen here? No. There's one. So this is where yeah, 16 3/4, but she has a felony, so a second-degree murder charge in Florida, a first-degree offense. Wait, hold on. All right, what am I doing here? This is that one I looked. I keep going to the same one. Tend to life. See, this is where it says mandatory under Florida law, 10 to life. A person who uses a firearm to commit must be sentenced to a mandatory minimum of 25 years. Yeah, but I'm going to go by that 16 point. And then she has that felony charge. So, I mean, I think the minimum she's going to get with that strangulation charge too is 20. I think if she goes through and gets found guilty, I think the least she won't get any less than 20, in my opinion. What do you guys think? There's no way, because her history, and then the minimum, they said 16 point. Does anybody understand though why it does say 10 to 20 is the minimum? And then if, firearm or felony, I mean, you could get it higher, but then if you just look it up, Google it, says 16 point whatever for the minimum. Laws are confusing sometimes. But yeah, I don't think she'll get less than 20. So depraved heart. Yeah. Yep. And then I think I'm going to end it, guys. Then I think I'm going to end it. How long have I been on? Already 2 hours. I always think, oh my God, this was such a short live, but compared to like most people, like this is a typical or a longer live. Because my lives are like 4 hours seems like a normal live, but because I do such, long lives, but yeah. 2 hours is not short. Okay, depraved heart. Is that what you want me to ask? It says the individual must engage in behavior that is extremely reckless and dangerous. The behavior must demonstrate a total disregard for human life. The conduct must create a significant risk of causing death to another person. 100% fits her. I mean, that fits it with that video they have. It's like, nope. I don't know how she's going to argue that. Right? Good night, Kim. Hey, soul. So wait, you said depraved mind is a degree of moral turpitude and mental depravity associated with a crime. Oh, I keep thinking, never mind. I don't have my screen share. I was thinking we were reading it with me. Okay, wait. Associated with a crime such as repeated and excessive acts of physical abuse or brutality, or acts that are outrageous, vile, and inhumane. So, I mean, I think, dude, they give you even if they give you 30 years, I almost would think that that's a good deal. How old is she? 40 something, right? I don't know though. Maybe it is worth fighting if it's any more than like 30, because I mean that's then her life. So it's like, okay, either I'm going to do life in here anyway if I do 30, or I could just try to fight it, have nothing to lose, kind of deal. Night, Christine. There it goes singing. Yeah. Yeah. Sure. Hey, Tennessee. She's getting emailing judges. This is still all day, every day. Timothy. Huh. Well. And thank you again, Taryn, for joining. And Groovy. Actually, say it since I was just typing it. But yeah. That's about it, guys. Thanks for coming and hanging. Sorry I didn't do the NK yet. This week, if not tomorrow or the next day, sometime in the next few days, we'll continue the NK stuff. I just been, today I've been going through these interviews for the Ezra case. So it's just going to take me a little bit to try to, because they're all audio. So it's like, I got to listen, figure out who they all are, and get some visuals, make a video. So yeah, it might take a little bit, but we'll start that whenever I get that done. But until then, I'm going to continue with the Chris Watts, just kind of going through that NK stuff, and also just slowly go through it all. Really, maybe at least try to do it like once a week, because I mean, there's so much to go through with that. Maybe even sometimes twice a week, depending on, what else I've got going on. And yeah. She can't not be awful. Yeah, right. I know, right? The phone pings. Yeah. Yeah. Oh, yeah. I've been through everything on that one. I just got to refresh my memory on that. All right, guys. Well, thank you again. And I guess the next one is what? September? Did he say? Is it still September 24th, or he moved it to the 26th? Didn't he move it to the 26th? I think. So yeah, that'll be the next thing, right? Pretty sure. Unless if something else comes before that, but I'm pretty sure that's the next scheduled one. Oh, I have been, Jonathan. I mean, kind of. I'm doing the Ezra one next. I mean, I don't. What do you mean old cases? How old are you thinking? Because I kind of have been. What case are you looking at? Oh, he said August 14th. Okay. Okay. Like I said, I don't. With me freaking trying to be in chat, I miss a lot. So yeah, okay. Thank you. Yeah, I'm gonna sleep so good tonight. I am. Cause last night was so good. I'm tired. Oh, wow. Yeah, that'd be interesting. Huh. I feel like that's a no-brainer though, right? August 1st. That's Randy's birthday is August 1st. Isn't Jerry Garcia's August 1st too or something? But I know Randy's is. My old friend Randy. The one that, yeah, some people know Randy. His is August 1st too. So yours is too. How old are you going to be? Wait, is it already? Oh, it was. It already. I'm like thinking of it like it's coming up. Well, happy belated birthday. Shoot, I should message Randy happy belated birthday. We're on on August 5th. Oh my lord. I was thinking it was still coming. Well, happy belated birthday. Yeah. Happy birthday. How old are you? 39? Okay. Oh, you're still young. You're still young. Not even 40 yet. Oh my god, these waters have been so hard to open. Okay. Did you do anything fun? Are you talking about like the stairs and stuff or the pings? Right. 39 for years. All right, guys. Good night, Rebecca, Jonathan, Soul, Sarah. I can't. Amara. Why can't I? I know you've probably already told me. You guys probably think I'm like, to pronounce people's names. I bet you've already told me how to pronounce your name, and I still can't do it. Amira. Amira. Is it Amira? Oh, I got it before you said that, Sarah. I promise. See, now it looks like I was figuring it out. Swear to God, the Amira came before it, and then I just looked at it. But I get credit that I figured that out by myself because most of the time I can't figure stuff out by myself, so I want one. Because normally you will help me or somebody, you know what I'm saying. But that one I feel proud because I sounded it out and then I came to it. You know what I'm saying? Silly. Yeah. All right, guys. Bye. Have a good night, everybody.